Well, good afternoon, ladies and gentlemen. It is officially afternoon now. And thank you for making yourselves available for this presentation. What I'm going to talk about initially is I'm going to just take you through the two main acts that deal with protected disclosures and whistleblowing. So the first act is the Protected Disclosures Act. So what that act does is it creates an obligation on the employer, on employees, on previous employees, and so on, to disclose any suspected criminal or irregular activities. It also creates an obligation on the employer to protect employees who disclose information. So protecting them from reprisals, from occupational detriment, and so on. So in essence, the whole purpose of the Act is to ensure that there's a culture of disclosure, that there's a culture of accountability, and all in an effort to eradicate criminal and or irregular behavior. So that's the first one, the Protected Disclosures Act. Then the next act is the Prevention and Combating of Corrupt Activities Act, which falls under the realm of criminal law. So the Protected Disclosures Act falls under labor law, and then the Prevention and Combating of Corrupt Activities Act falls under criminal law. And what it does is, I think that one of the main sections is Section 34, that deals with the duty to report corrupt transactions. And it also creates a threshold. So it sets a threshold of, if a transaction involves anything over 100,000 Rand, then that transaction must be reported as, it's peremptory, it's mandatory. It doesn't give a person an option of saying, okay, I won't report it, but it creates that duty to report corrupt transactions in the Prevention and Combating of Corrupt Activities Act. Now, I want to just briefly deal with what constitutes a disclosure in terms of the Protected Disclosures Act. So the Act defines it and says that it refers to any information about any conduct by an employer or an employee of that employer that shows that either a criminal offense has been committed, is going to be committed, or is likely to be committed. And if there's a failure to comply with any legal obligations, if there's a miscarriage of justice that's likely to occur or has already occurred, if the health and safety of any people is going to be endangered or has already been endangered, the environment, whether the environment is likely to be damaged or has already been damaged, and then of course the issue of unfair discrimination. Once again, there it's two-pronged, so it's either it would fall under the Employment Equity Act if it's a labor issue, or the Promotion of Equality and Prevention of Unfair Discrimination Act if it doesn't fall under labor. Then of course that if any of these issues are being concealed, or any matter arising from these being concealed, then that would be a disclosure. Please note this is a disclosure. It doesn't mean it's a protected disclosure. We'll deal with that just now. Then we've got this, you probably can't see the slide that is dealing with the...
I think the slides are up, Pretender. We have got it right at long last. You'll be happy to know.
Okay, I'm ecstatic. Okay, so what makes a protected disclosure, a legally protected disclosure, is that they would consider whether you've made the disclosure or the whistleblower's made the disclosure according to a substantively correct procedure, and that the person hasn't made the disclosure for purposes of personal gain, and of course that the person mustn't commit a criminal offense whilst making this disclosure, that it must be made in good faith, and that the person making it must reasonably believe that what they're reporting is true. And that's important, as Tanya will illustrate a little bit later. Then, of course, the disclosure must be made to an authority. There's a whole list of what constitutes an authority, and that's available at section 5 to 8 of the Protected Disclosures Act. Okay. And then I'll hand over to Tanya now.
Okay, let me deal with a case that it's quite a recent case, the National Institute for the Humanities and Social Sciences versus Laporto. It's a Labour Appeal Court case that was handed down end of last year. And it involved a CFO. Just very briefly, the facts, and I'm going to just distill the critical point of the case. Is it involved a CFO who was placed on he was employed on a 5-year fixed-term contract, of which 1 year was a probationary period. So what happened at the end of the probationary period, his employment was not confirmed, and he, in essence, referred an automatically unfair dismissal to the Labour Court, claiming that he had made a protected disclosure, and that was the basis in which his employment was not confirmed. So what transpired is he had disclosed that the CEO had a questionable relationship, is the term that was used, with a employee at Deloitte Consulting. And the second aspect of his disclosure, he said, was that that the CEO has not acted within her legal obligations in terms of the PFMA. The Labour Court found that there was a nexus between his disclosure, which was they said was protected, and his dismissal, and found that there was an automatically unfair dismissal, and awarded him both reinstatement and curiously compensation as well. The Institute appealed that judgment, and the Labour Appeal Court looked at the facts of the case and fundamentally disagreed with the Labour Court. Firstly, taking into account that there was in fact an independent investigator appointed by the Institute to investigate both the allegations against that around the poor performance by the CFO, as well as the allegations that the CFO had brought against the CEO, and concluded that there was no basis to the allegations made against the CEO, but there was a prima facie case against the CFO. And there were several recommendations around that. Interestingly, there was also reporting to the Auditor General, who eventually found that the PFMA did not apply, and secondly, and there was no basis to the allegations against the CEO. So the Labour Court, looking at that context, and also took, oh, by the way, there was another factor in that the CEO had taken legal advice before the disclosure was made around the poor performance of the CEO. And on that basis, looking at the facts, the court said that there was no reasonable basis to the allegations made by the CFO, and there was no reasonability to them, both in terms of jumping to a conclusion around the relationship and how that could have been criminal, as well as the PFMA clearly not applying in the context of this institute, and therefore it was not a disclosure, and therefore it did not constitute a protected disclosure, and in fact the appeal was overturned with costs. Very fascinating definition, looking very closely at the definition of what a disclosure is. The next case is that of Van Alphen, which also looks at this definition. Now, Van Alphen was a senior quality auditor at Denel, and she effectively made several allegations around the quality assurance department, and specifically that the quality assurance managers were not doing their job, and referred to the extreme chaos in the department. The employer instituted disciplinary action against the employee in relation to these allegations that she made, and she sought an interdict at the Labour Court regarding claiming that she had made a protected disclosure and was protected under the PDA. The court looked at the definition of protected disclosure and said that what she effectively was complaining about was the poor performance of the department. And that did not fall within the definition of the disclosure, and found that on that basis, the interdict must fail. I've just also highlighted the quote there that courts, this case and obviously the previous case of the Institute, the courts were very emphatic to say that it does not, they do not promote a restrictive interpretation. Because of the scourge in our country around corruption and the need to promote whistleblowing, a culture of whistleblowing, a restrictive interpretation should not be read into these judgments. And it's just important to note that as well. So moving on, Rutendo.
Yes, thank you, Tanya. Now our next slide deals with, considering what is an occupational detriment, and in essence, the Act says that an occupational detriment occurs if there's disciplinary action taken against a whistleblower. So there are various situations where a person will make a report, disciplinary action is taken, a person's dismissed or suspended or demoted or harassed or intimidated, transferred against your will. And in those specific circumstances, the Act says that would constitute an occupational detriment. Now, I think what's also important to highlight here is that, some employers will seek to include confidentiality agreements within the context of an employment contract. But now with the new amendments, the Act doesn't allow for that. So a person would not be subjected to any civil action or any sort of allegations arising from breach of confidentiality. So any sort of act by the employer that would fall under any of these concepts would constitute an occupational detriment. So this would be in the employment context of an employee in a specific workplace. Okay. Now, what we've also decided to highlight is the important additions to the 2017 amendment to the Protected Disclosures Act. And I think one of the critical issues is that it now creates an obligation on the employer to actually have a written internal procedure for how to deal with whistleblowers and how the reporting should occur. And it also prescribes timeframes to address the protected disclosure. So the timeframes are in respect of keeping that person aware or giving feedback to that person who's made the report. And, so it says 21 days, within 21 days, you must notify them whether you're going to be conducting an investigation or if you're not going to be conducting an investigation. It doesn't prescribe how long you should take for the investigation, but it says you must continuously be giving feedback to that person, possibly every 2 months. Now, the other critical addition, which was missing in the previous Act, is that the current Act now creates a criminal offense for providing false information in the form of whistleblowing, and I'll put that in inverted commas. So it now creates an offense if a person knowingly provides false information with the intent to cause harm to any other party. And it's an offense that is, of course, punishable either by a fine or or imprisonment, and to a maximum period of 2 years. So that's how serious a transgression in that fashion would be. Okay. Now, we've also considered the section 186 of the Labor Relations Act that deals with unfair labor practices. Okay, so there's a range of unfair labor practices that I'm sure all of you are aware of, but one of them at subsection 2D, it provides for in the event that there's an occupational detriment that is not a dismissal, then such an occupational detriment would constitute an unfair labor practice. So such an act a person who's a whistleblower would be able to refer that as a dispute, and it would fall under Section 186. If it's a dismissal, then it would fall under Section 187, which is automatically unfair. We're going in that direction. So, yes, Tanya.
Okay, this is very briefly. I've cited this Minister of Justice and Constitutional Development versus Chichonga. The Labour Court judgment is actually in some ways way more interesting because it deals a lot more with the facts. But I think what I just want to highlight about this case is that the Labour Appeal Court recognises that where a employee is targeted because of a disclosure, that protected disclosure they make, and they basically harassed to the extent that this employee was, it will attract a form of compensation and a significant amount based on the indignity suffered. So it's interesting here, it was 100,000 Rand that was awarded, and that was in addition to the 177,000 in respect to the costs incurred to defend this onslaught against their reputation that filtered into the press as well. Interestingly enough, this was in addition to a settlement reached between the employer and the employee in respect of their termination of the employment. So it's interesting that the courts will protect employees and also award compensation of significant amounts should employers proceed without substance action against an employee for making a protected disclosure.
Okay. So leading from there, you know, Section 187 of the LRA makes provision for a dismissal that is automatically unfair. And there is a clause that specifically deals with a contravention of the Protected Disclosures Act. So if an employee has been dismissed for having made a protected disclosure, then that would fall under Section 187 of the Act and would be subject to adjudication by the Labour Court.
Okay, the case of John versus Afrox is another case worth noting. In this case, it related to the head of talent management who noted a concern regarding the regrading of positions, and specifically one position of a woman who had gone on maternity leave and returned, and she was placed in a different position and her job was regraded. And she raised a concern around this at a more higher level, raised concerns repeatedly around it. And in fact, what happened is that there was a discussion around her leaving, and then what happened is when she didn't bite on that, they actually terminated her services for what it was almost a summary termination for incompatibility. She went to the Labour Court, but claiming that it was an automatically unfair dismissal, and she lost there, and she appealed to the Labour Appeal Court. And the Labour Appeal Court was quite critical in the approach taken by the Labour Court. Specifically, and without getting into the details, specifically around the hurdle that they placed before the employee, which the Labour Appeal Court said was incorrect, is that it said that the Labour Court had thought that the employee had to actually prove the correctness of the facts, which was not correct. All that they needed to do was show that there was a reasonableness in the belief that there was an issue around the regrading and there was something unlawful around it and problematic around it. So the focus is not on the proof around the facts, but they had to just show that it was a reasonable belief that there was a concern. So the Labour Court, just the quote there is that they looked and said, was it done? There was no ulterior motive given by the employee. There was no ulterior motive by the employee to raise the concerns that she did around the regrading. It was done in good faith. And she reasonably believed that the information was substantively true that she provided. And that she was dismissed for incompatibility was not true. directly, there was a direct nexus around the protected disclosure she made, and therefore it was an automatically unfair dismissal in this case. Okay. The next case, I've dealt with this in a previous webinar I've done around Section 188As, but I thought I'd just remind you around it, and that is that Section 188A(11) of the LRA provides that either party, where there is disciplinary action, and the employee claims that the disciplinary action is due to a protected disclosure that they made, either party may trigger an inquiry by arbitrator in terms of Section 188A. For those that don't know, an inquiry by arbitrator is a final and binding arbitration at the disciplinary inquiry stage. Very, very nice process, and it's interestingly, either party may trigger. And in this case, in clearly case, the employee wanted to proceed with the 188A, and the court deals with this very nicely and very practically and says, if an employee has made this allegation and wants to proceed and indicates they wish to proceed with the 188, it's peremptory. It's not discretionary for the employer to decide whether they go the 188A route. It's peremptory, and therefore once they seek that process, it's for the employer to stop the disciplinary inquiry and refer the matter to a 188A in order to continue with a disciplinary inquiry. And really the purpose of that is to ensure that an independent person hears the case at the outset so it can be dealt with and determined whether there's a nexus between the disciplinary action and the protected disclosure. Okay, Ratenda, now this is really what we wanted to get to. I know it was this discussion. I'm going to ask you to start with the first one, the first question we've put put there. Just to say before I start is that these questions are the ones that come up regularly when we speak to clients or when we're dealing with processes as TOKISA panelists. So over to you, Ratenda.
Thank you, Tanya. So the first question is, have the amendments to the PDA impacted on behavior? So I think, at least from my experience, there doesn't seem to have been a great impact arising from the amendments because there's still, I think, the element of fear of reprisals, etc. And people would rather, report anonymously than have their name down on a specific report. So I'm of the view that the amendments haven't impacted on behavior as much as one would have expected.
Yeah, and just around the issue, that last amendment you mentioned around false allegations being a criminal offence now, do you think that's had an impact at all? Do you think employees it's been a deterrent to make malicious allegations or not?
I think there's just a general, issue of people not being aware of, how they're supposed to be protected for one. And then, of course, the second issue would be now that if it's false information, there's sort of a gray line, because remember that even a suspicion, you have to report. If you believe that a transaction is suspicious, you have to report that, even in terms of the Prevention of and Combating of Corrupt Activities Act. So I think, yes, there is a risk that it could be a deterrent, but I also think that it's a good thing in the sense that it creates a balance. It's checks and balances of everything, that if a person is simply making allegations because they're malicious, which we sometimes come across, people simply create things. So to deal with those that deliberately provide false information, I think it was a necessary amendment.
Yeah, I agree. And I'm also finding that employers are putting this into policies as well, particularly like sexual harassment policies, that if somebody makes a false allegation, they will, from an employment, this is obviously, that amendment relates to criminal, but should they make a false allegation, it could lead to disciplinary action against the complainant who made the malicious or false allegation. So that is coming, I'm finding that the only change I'm seeing is that employers are amending policies, and I think correctly so, around that. The next one is the company receives a claim protected disclosure in the face of disciplinary action. I think this is a very common one that we're seeing come through. Any comments around that, Rutendo?
Well, I think what will be critical, because you must remember that there are some people who are disingenuous and who will, knowing that they've committed some form of misconduct, preempt the disciplinary inquiry by then lodging a protected disclosure or purported protected disclosure. So I think the issue of timing would be critical there to say what came first. So was it the issue of non-performance or was it the issue of misconduct? And of course, that person would have to show that there's a link, a nexus between the protected disclosure or purported protected disclosure and the disciplinary action. So it's not as simple as saying, because I've made a protected disclosure, therefore you cannot discipline me. I think it's a matter of taking each case on the merits and looking at the timing of it in order to ensure that the act is not abused.
Yeah, and I think I agree with you. The timing is quite crucial. Is on when the protected disclosure is made versus the disciplinary action, and whether there's a nexus. I do caution employers that if they are unsure or if there has been disciplinary action taken against an employee and there is a protected disclosure, that they either consider, both the employer and the employee consider 188A so that you get a true independent outcome. Alternatively, get an independent investigator to preferably from Tukisa, of course, to investigate whether there is that nexus before you proceed with a disciplinary action. Because otherwise you could be faced with an automatically unfair dismissal allegation at the end, a successful one as well. So I personally think it does depend on the timing, on how you deal with this, but certainly if there's any doubt, one should tread cautiously as an employer. The next question, Rutendo, is around social media. I know this is a special interest of yours.
Well, I think we're coming across more and more cases where people are being disciplined for what they post on social media. And what goes hand in hand with that, of course, is the issue of reputational risk for employers. So instead of, when a person posts on social media, on Facebook or WhatsApp or whatever the case may be, that information is no longer within the control of the employer or within their sphere of influence. So this is why it's important then to have a policy in place that deals with that. So a written policy that makes it clear, this is what happens. You cannot post on social media. This is the reporting channel, you know, in order to also manage that risk that's associated with posts that have already gone live and of information that had the employer known that this was the situation, they would have done something about it. Yeah. So there's an issue there. And of course, a social media post on Facebook or a widespread post would not constitute a disclosure, a protected disclosure, because it's not to an authority. You know, so a person might find themselves sitting with their own misconduct charges arising from posting on public social media.
Okay. Yeah, I agree with all those comments. And the idea of putting in a policy and making it clear. And if there's confidence in the policy and that the company is going to fairly and appropriately deal with it, it's less likely that an employee will go to social media around that. So the next one is around the complaint, and this has come up in many of our more recent processes, which the investigations are a consequence of an anonymous complaint. It's anonymous and the whistleblower refuses to disclose their identity. What's your views on that? And I know you've done a couple of these, Rutendo.
Yeah. You know, I think there's still room for people to report anonymously because in essence, you know, it's simply a heads up, you know, to say this might be the situation. And even if it is an anonymous report, it still deserves attention. So you'd still need to go and investigate and see, is it actually happening or not? Because normally, you know, with the complaints that are anonymous, the person doesn't want to be known, but they will name who they know. You know, they will name who they suspect is doing something untoward. you know, so
No,
at least it gives you a starting point.
yes,
And I think,
I think
yeah,
you're right. And there's still an obligation to investigate. It
yes,
may be that you're unable to get the information and you can only work within the purview that's before you, and it may
yes,
restrict what you can conclude, but it
yes.
can direct you into, and I do think that there's still an obligation to at least do a preliminary investigation to see if there's a basis to it.
Mm.
And what do you do if the whistleblowers left the company? Do you think that affects things? I know that's come up a couple of times.
Yeah, I think now with the amendments to the Act, you know, because even former employees fall under the purview of the PDA now.
Yes.
So I think you would still have an obligation to investigate.
Yes.
And I think such a person would still have access to report according to those reporting lines within the company. So I don't think that the fact that a person's left should affect whether an investigation occurs or doesn't occur or proceeds. I think it should still occur to find out if to properly ventilate and see whether there is any substance to the allegations.
Yeah, I agree with that. And the next question is, the allegations come up in another process. So it's not whistleblowed through a blowing through an authority, but it comes up it often happens, a disciplinary inquiry. I'm here because I'm being victimized because of this, or something like, or in a grievance process, or even I've seen it come up in CCMA and TOKISA processes. How do you deal with it then? Do you deal with it in the same way, in your view?
Yes, but I also think that, you know, if a person commits it to paper and lodges an actual grievance, that would be wonderful because it creates a foundation. Not to simply, you know, so if you're aggrieved, there should be a policy in place that deals with your grievances. Or if it comes up in a disciplinary process, surely it depends on the nature of the allegations. But as an employer, in order to mitigate your risk, you would have to consider conducting an investigation into those allegations. In a few of my matters, I've actually come across witnesses who then say, but I'm not the only one. There are others who've done this with me, you know.
Yes, exactly, exactly.
So he's the only one who's been caught, but he then says, no, but there are others who've also done it. So you've got an obligation to investigate, even if it's preliminary, to investigate those allegations, yeah.
And the next one, which is also very common, is that there's a complaint. They make themselves known, they say, look here, I'm telling you, but I want nothing to do with it. I'm not willing to give evidence. I'm not willing to give anything more. This has happened specifically I find in sexual harassment cases that this happens. Have you got a view on this?
Yeah, I just think that it depends on the nature of the alleged offense, you know, because I think with sexual harassment, it throws up a lot of issues regarding a person's dignity, a person's being. You know, in some instances, you actually have to do the processes in camera because the person can't sit there. So I think sexual harassment is slightly different. But when they refuse to give evidence of any other sort of misconduct, then I think that also in itself is a form of misconduct because you're refusing to assist the employer and yet you're aware of information that you're refusing to disclose that could benefit the employer. Remember, employees have a common law duty to act in the best interests of the employer. So failure to disclose relevant information is a charge on its own. But yes. I'm loath to say that in respect of sexual harassment matters.
Exactly. You have to treat it differently.
Yes.
I think.
Yes.
I'd be loath to bring that sort of disciplinary action against somebody who's a complainant in a sexual harassment case as opposed to a fraud or theft case, yes. In my view. And I'd love to hear what other people's views are, but I do think you can't force a complainant in a sexual harassment matter to come forward. Considering the nature of that allegation.
I think there's also another issue there, Tanya, that you know you sort of balance the interests because the person who has allegedly harassed the person also needs to be heard. You know, so you have to balance those interests. Yeah.
No, that's true. Is that it balance? If an allegation's been made, if you know that an allegation's been made against you,
Yes.
and I've actually had this case where there was a case. It wasn't one of mine. It was one of the panelists where an employee wanted the employer to proceed with disciplinary action against him. There was an allegation of sexual harassment. The employer decided not to proceed because the complainants didn't come forward, and they took a kind of informal approach and cautioned him against such conduct. And as per what the complainants wanted, didn't proceed with disciplinary action. And he was saying, I want my day in court. I want to prove my version of events, and I want you to proceed with disciplinary action. It was settled, but I can understand how a responding party would want to feel that way, The other questions and this is another one where there are allegations. There's no substance. They're very, very serious, but it's all opinions, there's no substance. There's no evidence to support the allegations that's available. How do you deal with those sorts of cases?
I think this is why it's critical with some of the matters to actually involve external people who don't have any knowledge or prior knowledge of the employees who work there, who don't have a working relationship, because sometimes if it's unsubstantiated, it must simply be said that it's unsubstantiated. You can't take action if the facts don't prove what those allegations are. So there has to be evidence, otherwise we're not dealing with it on a balance anymore then, so whatever you say goes. But I think if it's unsubstantiated, then it cannot proceed, if the allegations are unsubstantiated.
And there's a lot to be said for people believing conspiracy theories without facts. If something major happens, there must be something to it. It must have happened for a reason, and they will make up their versions for it, whether there's evidence for it or not. And the next one, a version, and I think the same principle and often what comes up, particularly around discrimination cases, is your mutually destructive versions after a whistleblowing complaint, where both versions are mutually destructive. How do you deal with those?
I think then you look at the credibilities, you look at how credible the people were that you interviewed. Sometimes a person that you interview could not have come up with such a story even if they had 100 years to come up with. You can see that there is no way that this person concocted this. You can see, and I think you end up being able to sort of measure and to see through the lies and the if a person exaggerates, you can see through the exaggerations, because sometimes that also happens, that people exaggerate things. So you sort of have to look at the credibility of the specific witnesses that you've dealt with. So I'm wary of totally saying each version is 50-50, because it depends on who told you the version.
Yeah, absolutely. And then it comes down to the credibility of that witness and making a determination. And if you're unable to determine who's more credible, I assume it falls on onus. And if the obligation is on the employer to prove the allegations, obviously they fail if the versions are equally probable. Just coming to the issue of the union, and this is a fascinating one where I'd love your view on it, is their role in the investigation, when it's become quite common where the union's been involved in the whistleblowing or advising the employee to whistleblow on a specific aspect, and there's a demand for a specific outcome, or they want a presence in the disciplinary hearing, which I've seen on several occasions in recent years. Any comments you've got on that?
Yeah, I think, it's a sort of gray area, because they have the rights to associate with whichever union that they want to join, etc. But I think in the employment context now, if you're dealing with whistleblowers and the whistleblower is the union, then you would have to keep them in the loop and give them feedback in terms of, are you going to investigate or aren't you going to investigate? And sometimes the anonymous submissions or reports come through the union, because the union doesn't tell you who it is exactly. They just say our members, you know.
Yeah.
And so even if it comes from the union perspective, such a report comes from there, then surely you would be able to then investigate it and see if it has any substance or not. But regarding
just in relation to that quickly before you continue, is what if the union comes with the allegations and says that they're not willing to disclose the members that have raised the allegations? So they want to protect the identity of their members.
Yes.
That's happened quite often. And is there an obligation on them, on the union, to disclose their where the information comes from, or is their duty to their member to protect their identity if that's what the member seeks?
Yeah, I think it would be important to alert the union that if they don't disclose, if they don't give you the witnesses to substantiate the claims or the allegations, then the allegations will be unsubstantiated. So that's a risk they run. So even if an investigation is conducted and no further corroborating evidence comes through, there's a real risk that nothing will be done, because nothing will be found and no one will be willing to come forward and say anything. So it's a risk that they run. They need to be aware of that, to say, if you want something done, then we will have to have people who are willing to come forward and put it on record. You know.
And what I must say we've done on occasion as Tukiso is suggest that when the investigation gets initiated, the union be involved at that point in determining the process, the panelists to be appointed to investigate, so that the union has the confidence that the process will be done properly. I have found then that the union has been much more amenable to disclosing information to assist the investigation than if they excluded and just left to the employer to investigate. So just that I found that that's helped unlock things quite considerably, is to be much more inclusive in their involvement in the process itself.
Yeah. But then that involvement is also sort of limited, because they cannot demand a specific outcome, because then what's going through the process?
Yeah.
You know?
Due process has to follow. I know we demand that this manager gets fired because of these allegations. No, but I think that's something, if they are included in the investigation, can be contained in the event that they're included in the process of appointing and determining the terms of reference. Around the presence in a disciplinary hearing, I'm seeing this more and more, and I've actually done a couple of hearings where I did one recently where two unions were in the room, one representing the employee and the other one representing complainants. And there was an agreement that the complainants union would be allowed to sit in on the hearing. On the converse, I've had a case also where the employee has not agreed to, in that case, the employee was not represented by a union. The union was present, and they sought that the union leave because they had not consented to the union being present. So, but the union wants to be present because they believe they were representing the complainants. Now, this seems like a clear-cut case, but have you got any comments on that?
Yeah, I think it's always a problem if they're not directly involved, because remember, the disciplinary hearing is different from ours because it's still an internal process.
Yes.
And it's supposed to be a confidential process. And I don't know what the purpose of the union sitting in would be if they're not representing the employee who's charged.
Yes.
You
yes.
know,
and exactly. And if you look at the principle of it, it's a private process, yes. And it's the employer that initiates it. And it's the employer that initiates disciplinary action. The union is a complainant and doesn't have a right to be in the hearing. But you can understand, especially with sensitive whistleblowing matters where they've been quite instructive in referring the case, that they would want that role. And it's interesting, like I don't have an answer for it. And I think principally they shouldn't have an automatic right in the hearing. But it was interesting that employers, and there have been cases where all parties have agreed that they are present to represent the complainants. And obviously the question I've got is, are they there for the full hearing or just for the portion where the complainant gives their evidence? And maybe that's something to consider. I'd love any views out there if you have a specific view on that matter. Then the last point that we've got is the interaction between surveillance and whistleblowing. And surveillance, we use it quite broadly here, is surveillance obviously of having cameras in the workplace, be it a physical workplace, to surveillance of emails, surveillance of, if you've got a phone, surveillance of WhatsApp or SMS messages, to surveillance, seems to be the new craze is surveillance of when people are working. So you actually have programs on your computer where you are able to monitor what people are doing minute by minute to see when they are physically active and productive. And the statistics are frightening of how between 1990 and now, how this has absolutely become, when in 1990 it was absolutely a minority of employees were being monitored to this extent, while it has become almost commonplace that all workplaces have some form of monitoring in that context. So, Retena, any comments around surveillance and whistleblowing?
Yeah, I think, you know, what comes to mind is somehow the surveillance issue has the potential of impacting on, say, levels of whistleblowing, because if already there are cameras in the workplace and the manager or the employer can check what's happening, then the likelihood is you'll be able to find that information even without having to resort to whistleblowers.
Yes.
So
I think that's very, very useful. That's very interesting. So why would employees whistleblow if they think they've been monitoring on every level, because they think the employer's going to pick it up anyway, or they should be. So, you know, it's interesting is we had a webinar a couple of weeks ago around accountability, and this might detract, the high levels of surveillance might detract from accountability and the employees feeling disempowered, and thirdly, their common law duty to whistleblow where they do see wrong in the workplace. And I don't know what the answer is, but it's interesting to see if there is a detraction from it because of the high levels of surveillance.
But I also think that there's an upside to surveillance in that, you know, usually the information you get is it's information that's on paper, it's generated from a computer, there's a limited risk of manipulation, etc., etc. So, you know, it's information that can be useful for the employer in trying to curb corruption within the workplace.
No. Gone are the days of cases without WhatsApp in your evidence bundles. WhatsApps, videos, recordings. I don't know, I haven't done a case recently where there hasn't been all of that. And I think it's become such common practice because of the high levels of surveillance in workplaces. So it is, whether it detracts whistleblowing is a different, I think, yeah, we'll have to, I don't have statistics on that, but I do believe there is an element to it. Let's move on to the tips that we wish to end with before we take questions. So we are having a couple of, seems to be having a lot of like, yeah, there we go. It's just come up. And I'm going to run through them, and Retendo, maybe you want to come in when you're ready. And you've touched on a few of these. I must say, first and foremost, I think the priority of any employer is to try and prevent the need of any whistleblowing by keeping a finger on the pulse. And in today's world of working from home, I think it's even more difficult to do so. Don't you? And Retena, I don't know if you feel, but certainly I think certainly what I mean by the pulse of the organization is really the corridor talk, that discussion over the water cooler, over coffee, etc., cannot be underestimated, the value of that in the workplace. So certainly I think that's, that has to be something which would detract from the need from any whistleblowing whatsoever, because employers should pick that up. The second one is and this is very common in employers, is this whole issue of a hotline or the equivalent of some kind of hotline where people can whistleblow through, so they don't have to go to an HR department or a manager, but they can go to an independent person from the organization. Now, interestingly, I'm finding that employers are sometimes confusing supports, employer assistance programs, EAP type hotline, support, emotional support, stress support, etc., with a hotline to whistleblowing hotline, which I think should take it. So what often you see in tender documents and requests for proposals is we need a 24-hour hotline for whistleblowing. I think employers need to think more cleverly around how they look at whistleblowing support, rather than trying to just see a hotline in the way that you'd see it for support groups. And therefore, what we're looking at as Tokiso is some kind of ombud system, independent ombud system to refer whistleblowing into, rather than a kind of a hotline. And that could be through online, but through an independent body that really can receive these and assess them very quickly and give employees confidence that they're going to get taken seriously and fairly and independently assessed. The third tip we've got is, I do believe, and from the work we're doing, is that there needs to be a distinction in how you deal with discrimination. That includes your sexual harassment cases, which we're receiving so much of, versus your corruption, fraud, theft type cases, and how you deal with those. Discrimination cases require a different approach, in my view, and a higher level of sensitivity and understanding of what constitutes discrimination and sexual harassment from your corruption, fraud, theft cases. The next point is, if through a hotline or referred anonymously, consider conducting a preliminary investigation before acting. What we've seen is, when there is an anonymous complaint, there's two ways employers may go, is that they may, which I find problematic, they may rather avoid and just kick it into a process and not really get anything done, which obviously legislatively you're not really allowed to do, because you need to act within 21 days. The other way that employers, I think, are problematically acting is they take a big dramatic approach to it, and they go and suspend people. They appoint a massive team without actually just doing a preliminary investigation to see whether there's any veracity to the allegations. Because could you imagine being on the receiving end if somebody said, Tanya Fenter stole R1 million, and you go and suspend me immediately? I'd be very, the consequences of that to a reputation, to the company's reputation, to any other matter, could have huge ramifications for an organization. So I think it's incumbent on an organization to have somebody independently verify whether there's any veracity to the allegations before instituting a full-scale investigation. The next point is ensure confidence in the process. Include unions where you can, where they have been involved in the whistleblowing as much as possible. Ensure that it's independent. Ensure that an appropriately qualified but appropriately profiled person is appointed to the process. And get advice if you need to call us for advice on this. We are there to assist in advising on how to constitute an investigation. We obviously will not advise on running your case, but only on the process itself. The next one, linked to the one around preliminary investigation, is don't jump to conclusions. Everyone jumps to conclusions. I have the saying, do you hit your wife question, and I use that guardedly, because if you ask somebody, do you hit your wife, no matter how they answer, they feel guilty. And I think it comes to the point that we mustn't jump to conclusions, because I must say, often with allegations, we tend to find that if you poke, it's just a misunderstanding of sort, or miscommunication, or a perception, and there is no basis to it. Protect the rights and reputations of all those involved, and that includes the complainant, the responding parties, as well as the employer. And finally, report back. It's a big bugbear of mine is in my reports, I say to the employer, and I think most of the panelists do, is please give feedback or give a copy of this report to the parties involved, or give them feedback in this respect of what transpired in this investigation. I've run through that very quickly because I know we want to get to questions. Rutenda, I don't know if you want to add to any of the points I've made.
No, I'm very happy, Tanya.
Have I covered everything? Okay, so we're going to move to the questions. I am looking up at my screen for those that are seeing I'm looking up, because I'm looking at the questions. A question from Graham. It says, yes, I understand the employee's common law duty, but what if that person's life is being threatened or family members are being threatened? Rutendo, any comments around when somebody's been threatened around having allegations made?
Yes, and I don't want to give, sort of like a blanket response to that, because yes, there are mechanisms to protect people from being threatened, so that would be to report to SAPS, etc. But I also think that then the choice of person that you report to, you need to then make a choice distinctively and make a choice to report to, if you report to an attorney who's outside of the organization, or you can report to any one of the commissions, Human Rights Commission or the Public Protector. You could make a report to an external body like that, and that would constitute an authority in terms of the Act. So it wouldn't have to be for you to, if you're threatened here at the workplace, it doesn't mean this is the only place you can make that report. And you can also make the report anonymously.
Yeah, and that is exactly, that's when anonymity does play a role. And it certainly is, it should be encouraged, but I think that the common law duty, obviously if somebody's threatened, you'd understand that somebody would be hesitant to proceed with the matter, with reporting the matter. I've got another question here, just around another case. It's the Kanyile Nomsa, it's the Dunlop Mixing and Technical Services case. Let me refer to it as that. Is that it's just been raised that the court further reasoned that non-disclosure of knowledge that it is relevant to misconduct committed by fellow employees constitutes a breach of the employee's duty of good faith. In other words, that a non-disclosure could be a breach of duty, and that is important. So it could be a form of misconduct in itself not to report something, just as it can be a crime not to report something, obviously corruption or theft above 100,000 Rand.
Yes.
Any comments around that? So it really talks to your points around.
Yeah, so he's in agreement then. So I'm happy with that. He agrees with me.
Yeah, well, the court agrees with you as well. The next question, how do you see, linked to that is, how do you see whistleblowing and keeping a finger on the pulse playing out with working from home? Any comments around that? That's a tricky one.
I just think that, with a lot of grievances that are lodged, it usually arises because of misunderstanding or misinterpreting the actions of others. So some people simply need to be heard. So even if you're working from home, you can still make time to still catch up. You can still have your Zoom meeting, still catch up with your fellow employees and your colleagues, even if you are working from home. And just keeping your door open, for them to still come to you if there are any issues.
Yes, no, I agree. It's just keeping that connectivity all the time with employees working from home, and maybe creating, hopefully, as things start normalizing, and I don't know what, as we talk about the new normal, I hate that term, but that there is still some space to connect with employees in a personal space, and using that for purposes of just connecting and finding out and touching base. But I think also employees mustn't just rely on Zoom and MS Teams. They must also pick up the phone and call people. And I know in bigger organizations that's more difficult, but there should be an obligation to speak to employees on a very regular basis, on a personal one-to-one basis. And I do think you'd pick things up.
Yeah.
But it's a tricky, and it's going to be a learning experience. I think that question is how to keep connected with people while working from home. The next question from Melissa is, how do you maintain confidentiality of a report and protect interests of privacy of the accused versus the need to give feedback to the complainant? Rutendo, maybe I will give you what we've done I've done in a couple of scenarios as Tokiso. I've seen panelists do, and what we've done as Tokiso. The one option is to have two different reports, or a couple of two different reports. One for disclosure to distribute, and the other, which is a confidential report, which has the detailed information that's confidential in it, that goes to a select person within the organization. So, and it's clear in the reports that that's been done, is that this is a report to give feedback to employees, which excludes confidential information. So it's not misleading, it just is clear. So that's what we've done. Recommendations can also be separated from the main report. The other option which we've seen, particularly if reports are going to be used in hearings, is where certain information is just almost blacked out on the report. You know, so you're unable to read sections. So those are the two ways of doing it. But I don't think giving feedback necessarily has to be sharing a report. I think it could be just calling somebody in and saying, this is what's going to be happening. We've done a report. I'm sorry, I can't share the report with you because of the confidential nature of the information in it. But I'd like to give you feedback and talk to the person about the feedback. The fourth one, we've done a lot of these sorts of cases. So one where we've seen where there's been a particular concern of the employer that it will be leaked to social media if it's being given or distributed out, is that an affected party, being the complainant in this case, was allowed to read the report but not take it with them. How's that for an interesting one? So they were actually allowed to read the report, a physical copy, but they weren't allowed to keep the copy. So they knew the outcome, they got the feedback, but they couldn't take it with. So we've been quite creative around this. Rutendo, have you got any other ideas?
Yeah, and I think also, you know, because sometimes a complainant will make certain allegations, especially with sexual harassment, and in your determination, you might find that it does not constitute sexual harassment.
Yes.
So now the purpose of then giving that feedback is to say they have considered all the submissions, and these are the findings. So that's why it's so critical to have an external person doing it, because that person's independent and impartial and coming from outside.
Absolutely.
You know, to be able to give that feedback.
There's another question I've got from Henry, is that do you have an obligation to tell an accused, somebody who an allegation is made against, that they're being investigated? Your view, Rutendo?
I think you will have to tell him at some time or the other, because you have to hear his version. And simply making an allegation is not enough, hey? You can't just allege that such and such is being done and that person is not given an opportunity to respond. I mean, that goes to the core of Roman Dutch law, you know, so that person has to be made aware that this is the situation, but it's with the provisos that you can even suspend him whilst you investigate.
Yes.
But you still have to give him an opportunity to also deal with whatever it is that comes out of there.
Yeah.
You know?
I agree. And I personally, if you look at the guideline, Tokiso's investigation guideline, we actually recommend that unless there's a good reason not to, you actually, I'm talking from a panelist perspective, when Tokiso conducts an investigation, we recommend that there be a very brief preliminary meeting with those that are accused in the allegations to introduce yourself and to say we're investigating these allegations. We will give you an opportunity during the course of the investigation to respond. Because what that does, it comes back down to that tip where we say, create confidence in the process. Because yes. I couldn't think of anything worse than somebody finding out along the way they've been investigated and they've not met the investigator or not been told they've been investigated. If I was in that person's shoes, I'd be very, very upset. Yeah. And understandably so. I've got another question. I know we're running over time, but I'm going to take it anyway because they're coming in fast and furious. Julia asks, it says, it is my view that often employees disclosing information or making allegations have a perception that they are in a position of power, hence a demand for immediate suspension of implicated employees or parties. Employers should also realize their obligation to protect the implicated employees until such time as a preliminary investigation is done. So, Julie, you're agreeing with that view. So another part to your question is it in order, for example, in the above situation, for a more undercover, quiet investigation to be conducted in relation to the allegations made? I think the quiet or undercover one that you refer to, in my view, is the preliminary one, is to maybe just take a kind of a look at it, see if there may be another explanation to it. You know, don't go into formal investigations with people, but take the investigation and assess whether there could be a basis to it. And if you're talking about undercover in that context, I would say yes. So don't tell anybody about it yet, but just assess whether there could be veracity to it before you proceed with a formal investigation and start interviewing people. Because the problem with especially anonymous allegations is people can make any allegation anytime, anywhere without consequence if it's anonymous. So people can say anything. And I do think there's an obligation on an employer to do that preliminary step before they go into a formal investigation. Otherwise, it could cause mayhem in your organization. Another question from Wally is a grievance procedure enough, or does one need a whistleblowing procedure? Rotendo?
I think that you need a standalone procedure, because even the Act says you must have a procedure. It's peremptory now. The grievance procedure can still exist. It doesn't mean it's not, you know, useful anymore. And it might be for certain types of alleged offences. But in respect of this one, which is the protected disclosure one, I think it should be specific, a standalone policy that deals with it in compliance with the Act.
Yes, I agree. And we must make sure that they dovetail your grievance procedure and any other policy that you have, dovetails. That's crucial. But I do think what the objective of any whistleblowing procedure needs to be is to create space, a comfortable space and a facilitative space, if I may use that term, for an employee to readily report a matter should they deem it necessary, and very easily so. Okay, we do have several other questions coming through. I see there's a couple of questions specifically around the ombuds concept. But I think what I'm going to suggest is we will take those offline with those that have those questions. Otherwise, feel free to contact us. It's for me to thank Rotendo. I trust it's warmer there than here in rainy Johannesburg. But thank you very much for your insights and sharing them with us today. For those that wish to book Rotendo for a matter, of course, please to go to our online system, and Rotendo's dates and availability and a profile are up there to look at. So thank you very much, Rotendo. I don't know if you've got any last comments before we end.
Thank you very much, Tanya, and I thank everybody who's attended. Yeah, I hope you have a wonderful week going forward.